is always free and confidential. Our mentors are volunteers that come from all kinds of different backgrounds and experiences, and they're wanting to help the small business community to be successful. The nice thing about SCORE is that it is a national organization. So for any reason we can't assist you at the chapter or district level, we can reach out to the national database to find somebody that can assist you. So you might be wondering, how do I get a mentor? Well, that's super, super easy. You can put a little note in chat to me and I'll make sure the right chapter reaches out to you. You can go to the website and I will put those chapter websites into the chat as well. Or you can email me and I'll put my email in there as well. And you can email me and I will make sure the right chapter contacts you to set you up for an appointment with one of their mentors, the one that for wherever you are from locally. If you already have a mentor and you haven't met with them in a while, it is a relationship that can continue on us for as long as you like. And they can work with you, hear your new ideas, help you with business growth, planning to develop your business, to keep it growing, et cetera, et cetera. And they're very good at working with folks on a long-term basis and can bring in others as needed to help fill in any gaps. We are we'll utilize Q&A today. You can put questions into Q&A that you would like me to ask our presenter, Bill, or you can put stuff in chat, any other information you would like addressed in chat. All right, that does it for my SCORE intro. So I would like to introduce Bill Helsley. He is a SCORE Boston mentor. He's also one of our co-chairs, and he is very knowledgeable in the legal arena and has a lot of information to share with us. So it's all yours, Bill.
Thanks, Teresa. Hi, everybody. It's always hard to know what to say right at 12:05. Is it good morning or good afternoon? So it's nice to have you. I don't know who among you was with us for the part one of this, which dealt with legal entities. But today we're going to cover let's see here. Yeah, well, we're going to cover a range of topics that are not necessarily all related, but they're meant in conjunction with the first presentation on legal entities to try to give you an overview and a summary of some of the recurrent and important legal issues that come up when you're running a business or thinking about starting your business. I know there's an important workshop coming up on insurance and other risk management matters. That's a really critical part of any business's business planning. And to echo something that Teresa said, all of this stuff, which is a little more granular, we really want to have in the context of your business plan. And to Teresa's point, when we understand your particular business, what service or product you have to offer, we can drill down on some of these things and start to give you more specific types of information. So feel free to, I see there are some things in chat. Just fire those questions out or the Q&As. And if I miss them, Teresa, feel free to let me know and I'll answer those questions if I can in real time. So today we're going to focus on a couple of things in addition, as I said, to the legal entities. We're going to talk a little bit about leases now that we're moving back into the brick and mortar world, talk about some standard contract terms, some licenses, a very brief overview of intellectual property, trademarks, patents, and copyrights, and then just a little bit about insurance, which will be fleshed out later in a more detailed workshop, I think, on insurance and other risk management. So let's just start on the assumption that you're in business. And again, these are not particularly related, but typically when your business is starting or up and running, you want to make sure that you're licensed to do business if a license is required. One site that I like to refer to is called nolo.com. You can pay them to set up your business and everything, but they have a wonderful step-by-step that you can use to figure out what you need to do to get yourself set up, A, but B, they typically reference needed licenses and so on. A couple other of tips, whether you're in Massachusetts or any other state, if you go to the Secretary of State's office, there is invariably a tab, and you can Google it. You can just say how to conduct business in state X. If you literally do that for Massachusetts, it will tell you everything you need to do to get yourself set up. The same thing in the city of Boston, for example, they'll tell you. And if you need a license to do something, particularly if you're in a regulated industry, if you're a lawyer, an architect, a hairdresser, chiropractor, they'll tell you what licenses you need. And on the municipal level, if you're conducting business in certain states, or in certain municipalities, they might require licenses as well. Boston, for example, just initiated a new process for home kitchen work. So you can make your food at home now, get your certification, and go to the market with that, as opposed to having to connect with a commercial kitchen. So it's just one of those things you want on your little checklist of things to do, is to make sure that you are properly registered. And part of that is, when we talk about insurance, is typically your insurance coverage will require that if they're insuring you, that you have all your proper licenses in place. And if you have an event that your insurer is being asked to respond to and you're not properly licensed or registered, they might decline coverage. So it's just one of those little things you have to take care of. So just put that on your little checklist. And of course, we're always here to walk you through those things. Moving ahead, for those of you who are currently in a brick and mortar situation or are anticipating it, leases are tough, and we're going to spend a few minutes on them. I'm going to refer mostly to Massachusetts because that's what I know most. But quite often it's the largest expense your business will have. It's a predictable expense. It often includes a commitment anywhere from a year, if you're lucky, to 5 years. And, I think many of the mentors in our chapter have been sad to find people who come with a business idea, but they've already signed a lease. So they've got a 5-year commitment. In one case, I talked to a woman who had an idea for a restaurant, but she had already committed $500,000 to lease expenses over 5 years without knowing whether the restaurant could even succeed or fail. Landlords typically make their living off this. They're very sharp about what they do. So what I want to talk about here a little bit is how you can think about the terms of the lease, how you can negotiate some of those terms to a better advantage. And again, the role that we can play. We can't be your lawyer, but we have a lot of people who are used to negotiating commercial leases and can help you negotiate those and identify terms places where you can push back, or maybe the landlord is asking for a little more than is really commercially appropriate. So obviously, as part of your business plan, and like with any real estate, location. If you are looking at a lease for commercial space, where you're going to have that footprint is really a critical part of assessing ease of access by your customers, your clients, where you want to be, if you're a warehouse, where your transportation needs are. So you need to do that. The kind of good news, at least in this area, and I suspect nationwide, is there is a lot of commercial space available. There are a lot of people who are upside down in current leases who are looking for subtenants who can come in. So if your business plan justifies making a commitment, this is a good time to be looking for space. And again, we have people who can help you with that. The other thing I suggest, and I think my colleagues suggest as well, is that you give some thought to working with a commercial broker. Now, if you're looking for 1,000 square feet, maybe you're going to be very localized in that. But, if you've got a bigger requirement, or you have some sophisticated needs in your space, clean labs or whatever, use that commercial broker. They know the space. Typically, the broker is paid by the landlord, not the tenant, and they can help you navigate this market, again, particularly if it's one of your first times. So one of the first things, just to kind of walk through some terms that you're going to see commonly, is the first question is, in addition to your rent, what else are you going to pay as part of the lease payments? And one of the most common one is what's called a triple net lease, where you're going to pay, in addition to the rent and your share of utilities, either on separate meters or whatever, that you're going to pay all of those other expenses that the landlord would be paying: real estate taxes, insurance, and maintenance for your footprint of the building. So if you have the whole building, it's an easy thing. But when you're in a multi-tenant situation, the one thing you need to understand is the ratio, between your footprint, your square footage, the total square footage of the building. But you also need to understand that there's a third piece. There's you, there's the other tenants, and then there are what are called common areas. So the common areas, the entranceways, maybe areas that are off limits to anybody other than the landlord. You can be able to push back there and say, well, those are really the landlord's responsibilities. And in addition to that, under the category of maintenance, there are typically, for a landlord, areas that the tenant can push back and say, these are your responsibilities to care for. Things like the roof, the exterior walls, exterior windows. So when you're looking at that lease, you can see a lot of information buried in there, typically under a headline like landlord's responsibilities, tenant's responsibilities. And the best thing for you as a tenant is to be thinking about what you're responsible for within the four walls of your leased space, and then see how much of that you can push off on the landlord outside of that. But if you see a term like triple net, again, that means that you're going to be responsible basically for your pro rata share of all of the landlord's costs associated with the building. So the next term, and again, these are not in any particular order, is when you're negotiating a lease, particularly a new one, but even if you're upgrading and you've been a good tenant, it's a good time to ask for some concessions for the landlord. You might be moving into a space where non-load bearing walls need to be changed. It could use some freshening up with new flooring, new paint, maybe some new lights, new signage if you're in a place where it's outside the building. And this is the time to get those concessions from the landlord. And it's, again, it's never going to shock a landlord if you ask for these things. They may push back, and some of it's going to have to do with the economic value of the lease. If you're signing a $3 million lease, over 10 years, they're going to give you more concessions than if you're signing a $30,000 lease. But it's, try to think about what you're going to need. Who's going to pay for those costs to make this space that you're leasing ready for your business? And think about pushing back on a number there. And again, we can help you kind of frame that ask with the landlord when you get to that situation. So the next item in terms of this, just like one item is how much am I going to pay, the next item is how long am I going to pay this for? So there are two basic forms of tenancy in Massachusetts. One is where you identify a term for the lease. It's a year, 3 years, 5 years, sometimes with a renewal clause in it. The other type of lease is called an at-will lease, where you or the landlord can, on some notice period, 30, 60 days, decide that you're going to terminate the lease. The point of an at-will is it doesn't commit you to that term of the lease if you're decide the business didn't work or you're not in the right location, you can get out. But it also gives the landlord that flexibility as well. So you need to kind of balance the pros and cons of having that firm commitment and how certain you are that you're going to be in there for the term, or do you want the flexibility along with the risk of you or the landlord deciding that you're going to get out? So moving allowance and landlord's construction obligations are pretty much the same thing. And again, I don't know how many of you are thinking about leases, but this next clause here is a critical one. If there's anything in the lease that limits your rights to the space or is going to require you to take on additional expense, for example, under the Americans with Disabilities Act and the mass version of that, if you undertake a certain level of upgrades, particularly in an older building, you may need to do some things to upgrade the physical accessibility of the space. And a lot of times that limitation will be on, or that expense will be on you as the tenant if you haven't anticipated that. Had a woman who leased some space on the ground floor and the basement, hoping to use both levels of the building for her nail salon. And she wasn't well represented, sadly, but the tenant or the landlord kept his mouth shut, and she ended up executing a lease and was told that it was going to cost her $100,000 to get the basement space up to code because of the renovations that she wanted to make, or else she wouldn't be able to use it as part of her business. So again, you need to understand those things, that we can help you to some extent to point out what the issues are. If you're investing a lot of money in a lease, having a good real estate attorney might be money very, very, very well spent. In terms of options to extend, typically goes along with proposed upgrades in your rent. You know, if you extend for 2 years, that's a good time to negotiate what your cap will be on rent over the next 5 years or the second term of the lease. A lot of times those are tied somehow to the consumer price index. But again, these are business terms that are going to affect your costs, and you want to know what those are up front as you're negotiating these terms. And again, I just will point out that commercial landlords are typically very, very good at what they do. And so they understand everything that's in that lease, and we're here to help you, but you need to understand those things as well. So options to purchase, you know, sometimes a commercial landlord will put the space on the market. And if it's the whole building, for example, you might have a right of first offer, a right of first refusal. We don't see that a ton in the size of businesses that we typically do, but sometimes, you know, it's a one tenant building, and it can be nice to have that option. Assignment limitations, this has to do with subtenancies. If you're in a situation, we see this sometimes in the health professions, where a person will run a suite of offices and intend to rent out some of the spaces to other similar healthcare providers or like-minded wellness providers. You need to understand what those rights are. You need to understand what your rights are. If you have to get out of the building, do you have the right to sublet? What are those rights? How do you get out of them? The default and remedies, again, once that lease is signed, this landlord is going to expect you to live with it, because they are, you know, that's their business, and they build their cash flow projections based on you fulfilling the terms of your rent. And of course, you build your expectations based on the landlord doing what they hope, they tell you that they're going to do. So you need to understand what your rights are on default, what their rights are on default. And typically, if you default, the landlord has the right to come in. Let's say you have a repair obligation in your premises and you fail to do it. Typically, a lease will say that they can come in, fix it, and then charge you for it. So you need to really, again, I can't stress this enough, just really understand all of these details and think about them up front. So subordination and non-disturbance have to do with two different things. One is oftentimes, even when a commercial landlord signs a lease, they will take out a mortgage in anticipation of your paying your rent for the anticipated period of time. And so the subordination agreement means that you will agree that your rights will always be subordinate to the right of any mortgage holder that the landlord has granted a mortgage to on the property, and even maybe liens for other purposes. And a non-disturbance agreement has to do with what rights you have if another tenant is acting up or so on. Let me see your question here.
Yeah, how can you avoid having a small tenant avoid having to sign a guarantee?
Yeah,
lease?
that's such a great question, because you do everything and you typically set up your LLC and the landlord wants to have you personally guarantee the lease because you're a new business, or they worry that your capitalization of the business doesn't give them enough satisfaction. It's actually kind of hard to do. One thing you can do is push back and say, look, I'll do it for the first year. Let's say I'm going to sign a longer term lease, so they see some commitment. You can say, I'll guarantee for the first year, and if let's agree that if I make my payments, you'll take me off. But it's very common to do, and you frankly don't have a lot of leverage unless you can show that the business that you're bringing in has good financials for years past. Maybe you've been in another location, maybe you've already leased. So part of that would be satisfying the landlord and making the landlord comfortable that they don't have the risk that they're asking you to cover individually, because your business is solid and up and running and has good financials. But you can always try to negotiate that by saying, look, I'll show you my books under a non-disclosure agreement, but you can see we're well capitalized. Again, there is some leverage because there are a lot of spaces available. And if you're looking for a bigger space, I would push back and say, we're not a teeny little business here. I think if you're looking for something in the $1,000 to $3,000 a month kind of range, and you look like a newer business, you might expect that. But again, you can push for the length of that. And you can say that it doesn't have to be the entire term of the lease. Let's have a make good period for a year, and both agree that if all the terms of the lease are met on my end, you'll remove that. Was that useful? I hope. Just let me know if you have any more questions there. And so the other area there are two areas here. One is force majeure, which the whole world changed because of COVID. And there were actually a lot of leases that didn't include force majeure language. And a force majeure means a superior or outside force that prevents the parties from doing what they contracted to do under the lease. A war, a fire, something like that, what used to be called acts of God. But of course, the big one was pandemics, that nobody anticipated the whole world was going to get shut down. And that's why you saw the government stepping in to say, we're going to stop enforcement of lease foreclosures or lease defaults for a period of time. And Massachusetts courts wouldn't even hear a litigation from a commercial tenant until last fall, I think. So you want to make sure that that lease is broad, that it excuses you and the landlord. And a related term for that has to do with things where there's government takings, or there's something like a fire in the building that keeps you from being able to use the space that you've leased. And those clauses can be tricky. You will have insurance on your rights as a tenant to protect your interests, and we'll talk about those a little below. But a lot of times, if you're not careful, you can be in a situation where the landlord has made you stay obligated under a lease, even though it's going to be a commercially unreasonable time for you to sit without access to the building. So it's a clause that it's often way down in there and your eyes are getting tired from reading the lease, but it can be very important if you have a loss like this. So both of those clauses are important. Pandemic language is now in there. Of course, that's maybe not the next thing that's going to come up. But again, just to we'll move on here. But I think the takeaway here is that these terms need to be, thank you. My wife brought me a glass of water here. The takeaway is that these leases are serious, and we need to make sure we understand all of those terms. So if there are no more questions on those, I'm just going to move to another very important topic. If you're in the business of hiring people, whether as an independent contractor or as a worker, let me start with this one, even though it's a little further down. If you're in Massachusetts, unlike a lot of other states and unlike the federal rules, Massachusetts wants employers to categorize workers as employees because they want them in the benefits scheme. They want them in workers' comp. They want them in unemployment compensation. They want them to get health insurance if that's required by law, and maternity benefits and so on. So the test in Massachusetts is pretty simple. There are 3 elements to it. And if you just Google Mass Attorney General worker test, you'll see it. But the one criterion that always trips people up is that if the worker is doing business in the same field that you are, then Massachusetts is going to expect you to classify that worker as an employee. So an example I use is if you're a plumber and you want to bring in plumbers, even though they have their own tools, they do their own jobs, maybe they have their own business on the side. If you're a plumber and they're plumbers, Massachusetts wants you to treat that person as an employee. And so if you are a plumber and you need to bring somebody in to frame in, something or do some carpentry work, that carpenter can be listed as an independent contractor. So, but if you're with very few exceptions, there are in the hairdressing, for example, people rent chairs and so on. So unless you're hiring somebody that's another business, if they're working in the field that you're in, Massachusetts is going to want you to treat that person as an employee. And it's not particularly a fair law for small businesses because, we're not big construction companies or so on, but people do get in trouble. The place you are most likely to get in trouble is actually the worker that you hired and that you misclassified. Even if they agree to be misclassified, because they think they're going to get more money and they don't care about benefits or whatever, they can still turn around and complain to you. So they can't waive their rights to be properly classified as an employee. Now, the big issues, I'm going to move back to the top here. Massachusetts is a state that permits you to hire an employee at will. And that means that the employee can be fired for no reason or any reason except for a prohibited reason like discrimination. But the employee can also leave for any reason. So it's kind of like with the lease, whether you have a term or not. When you bring an employee in, do you want the comfort of knowing they're going to commit to you for a period of time? Or do you want that flexibility to know that an at-will relationship exists so that if for whatever reason you need to let that employee go, you can do that and there's no downside to you that you owe them for a promised term of employment? And the issue comes up there when the employee says, well, you promised me a year at $5,000 a month, so we had a contract and you breached the contract and now I want the remaining period of time. So you don't want to get in that fight. And you do that by avoiding at will. There's not many situations that I can think of, frankly, where it makes good sense to have a term of employment. If you and the employee are happy and are working together, the relationship will continue. And if they aren't, you don't want to have been tied up in that kind of thing. So keep that in mind. Non-competes, as of about 18 months ago, the law changed pretty significantly in Massachusetts to restrict the right of an employer to put a non-compete into an employment agreement. So a non-compete is where the employee agrees that for a period of time after employment, they won't work in the particular field that they've been hired to work in. They won't try to solicit business, which is a little different. We'll talk about in a second. But the non-compete now requires some additional compensation, typically in the form of agreeing that if you terminate the employee and there is a non-compete in place, you're going to give them some extra compensation. It's an old English term called garden leave, where they can go home apparently and sit in the garden for a little period of time. And then at the end of that time, then that non-compete would kick in. The exception here is that if you are an hourly employee, somebody that's not exempt for the wage and hour laws and entitled to overtime, you can't enforce a non-compete if you terminate the employee. So if the employee leaves and they're an hourly, the non-compete is enforceable. But if you terminate them, even at will, even for no cause, even if you have the non-compete, you're not going to be able to enforce it against that group. And again, the thinking is that hourly employees don't have the kind of skill sets that can really actively compete with another business. So two areas that you can always enforce have to do with non-solicitation and non-disclosure of confidential information. And the issue there is, if you're working for someone or someone is working for you, they're going to start to learn information about your business. They'll learn who your customers are. Maybe they'll learn who your best workers are. And they want to protect the owner, the employer's interest in those assets. So those are enforceable clauses where you say for a period of time after you leave for any reason or for no reason, you won't solicit my customers, you won't solicit my employees. And a related term has to do with non-disclosure of confidential information. Again, things like pricing, things like who your clients are, if you're working in a field where you have proprietary practices or you're working on a big deal with somebody, your marketing strategies or what have you, all that stuff should be addressed in a confidentiality agreement. And those are enforceable against anyone. The key here is always, and as a lawyer, I tell everybody this, it's enforceable on paper, but the reality, if you've ever been involved in litigation, can be that it can be a slow process. It can be an expensive process. So, you don't just get to march in the court with a piece of paper a lot of times and get the person to stop doing what they're doing. But it's very, very useful to have these in your contracts. It sets the right tone for your workers when they come in. Oh, sorry. So compensation and benefits. The first thing, again, is, are you properly classifying your employee? Some employees can be classified as salaried. And again, there's great information on the Mass Attorney General's website about the different categories of workers. But a lot of times people want to classify an employee as exempt from the wage and hour laws because they don't want to pay overtime. And that's just an area that the Mass Attorney General is all over. And whenever they hear it, I saw a very unfortunate exchange with a woman who I just made a mistake, but the tone of the messages she was getting from the Attorney General was really pretty threatening. So you want to make sure you have that right. They are there to help you. I know people can be a little mistrustful of state government agencies, but if you call them, they'll give you their best answer. And they'll, particularly in areas like sales work, commissioned work, working on the weekends where the laws have changed a little bit. It's good to understand what your rights are. We're here again to help you talk through those things if you have questions, but don't rely on kind of word of mouth or what other people have told you about what the right way to do this is. This is a time of very active enforcement of worker rights. So you don't want to get a call or an email from the Mass AG saying, oh, we think you violated these folks' rights. It's small businesses find it hard to come up with a standard employment letter and a standard handbook. You want to get your work done. But if you get to where you've got a couple of employees and you need to do this, you anticipate growth, then you do need to really think about getting in writing your offer letter, the terms of that, what the terms of employment are going to be, if there are going to be benefits related to that, and some of these benefits are required by law as you get to a certain size, like maternity leave and healthcare leave now, access to workers' compensation. So you need to spend a little time on this. I know it diverts from your business. There's great templates if you use something like a payroll service. Almost all of them now have an arm of the service that deals with standard documents that are applicable in Massachusetts. So you can typically buy into that as part of these payroll services. There's so many of them out there. And we can help you again to think through what your minimum requirements are. Again, the state under that How to Do Business in Massachusetts tab will let you know what you are required to do based on the size of your workforce. And then the last one that I just can't stress enough, because I know there are a lot of our clients that are in service industries and it's hard to find people to do the jobs. But the risks of being caught for improperly hiring a worker who isn't work eligible in the United States, the risks are going up and the penalties are non-trivial. They're typically a function of how many days the person was working and so on. And again, the risks can come from a lot of places. A competitor, the risks can come from a dissatisfied worker who was fired. So I know it's a hard process. I know it's hard to get people, but I also know the reality of what's out there. And I don't mean to lecture you, but if you're in a business that is dependent on people that or suspect are not legally working in the country, you're taking a big risk. And we can talk to you about that. There are a few visa categories available. But again, we don't want you to be in a position where your whole business model is based on something that could be gone when somebody calls the federal government or Massachusetts and says you're not doing it right. So again, give us a call if we can help you with that. I'll take a quick stop. No questions I see on either of those. So I'm going to move now, as I said, to kind of an entirely different area, which is contract terms. And so if you think of risk a little bit, and we've been talking about risks in the context of the risk of making your lease payments or having a fair lease, the risk in terms of your relationship with your workers, other than the risks associated with you actually delivering your product or service, this is an area of contracts relevant to your agreements with your clients, or your subcontractors, that you can do a lot to protect yourself by contract. So I used the term last time of the three-legged stool of risk management, and one is your insurance policies, and the terms in your contract here is the second leg of that stool. So some of the things we want to talk about, and a colleague of mine and I have put together a suite of basic templates for contracts. So you can contact Teresa or you can contact me and we can get you in touch with people. Typically, there are great templates out there on the internet that are relevant to your profession or your service. So, you can hunt around those, and we're happy to look at those agreements too. But they all try to cover the same kinds of things. And so just let me spend a few minutes talking about a couple of them. One is, there's a big chunk of the contract, right, that we want to talk about, which describes the job, how much you're going to get paid or how much you're going to pay your subcontractor, what the deliverables are, and what the schedule is. So we combine the scope of work with a master services agreement. And when we're thinking about somebody that's going to be a recurrent client, let's say you hire carpenters job after job, you're a contractor. So what you would want is a master services agreement where in one negotiation, you hammer out all the legal boilerplate, the indemnification, limitations of liability, insurance language, and we'll talk about those a little more. But then you never have to revisit those terms again. And you would want to do that perhaps upstream too, if you typically provide services over and over for a client. So you want to get that master services agreement out of the way, and then you can negotiate what's more important to the business, that scope of work on a job by job basis. So what you would break that into two documents, and every time you had a new engagement, you would simply say the master services agreement refers to scope of work number 2, number 6, whatever. And that's a nice model because it speeds up your contracting process. And again, lets you focus on these things up here in the scope of work, which are most important to you in terms of getting the job done and so on. And so that is just a faster way to do it. If you're in a business where you tend to have a series of one-off clients, we've seen a lot of people that do home decorating or home repair where they come in for one job, then you would, in that case, merge your paperwork into one document where you'd have your boilerplate there. But again, the critical piece and where we see most of the friction between a client and a worker or a service deliverer is in the scope of work. So detailing that, making clear what's there, if there are specific deliverables on typical specific timeframes, those are things that you want to have really spelled out in as much detail as possible. So exclusivity is something a lot of times you want to watch out for. If a company is hiring you and you do some kind of work that is a little more refined, you do materials testing. I had a client that does medical device testing, and he got a contract from a bigger medical device manufacturer that wanted him to be exclusive to them in the field he was working in. And he said, look, you're not paying me enough to give you exclusivity here. So you need to be able to push back. And a good way to push back there is to say, look, I'll give you confidentiality, but I can't give you exclusivity. Obviously, I wouldn't tell another client about what I'm doing for you, but unless you want to hire me full time, I can't have you be my only client. So these next 3 items here, warranties, indemnification, and limitation of liability, are really where the risk management comes in. So a lot of times in a contract, your client may want to impose on you, or you may want to impose on your subcontractor warranties, which are contractual terms where you agree to certain things. A warranty might be that your product doesn't infringe on the intellectual property of someone else, or a warranty might be that your work will meet the highest professional standards instead of industry norms. So you're taking on a higher promise in terms of what you're going to deliver to the client. So you want to think about those warranties and make sure that they're very limited and appropriate to the scope of the service that you're providing or the scope of the good that you're selling. Like a lot of times in the context of goods, there's a warranty of merchantability or fitness for a particular purpose. And what that means is that you're promising the customer or the client that what you're selling them will be good for their purpose. And you need to push back on that. And you need to tell them, no, that's your job to determine. I'm going to describe to you what I'm going to sell you and what I'm going to deliver to you. But the end use for that is solely your decision to make with regard to your anticipated use of the product. So indemnification, I'm sure you've all heard that term, and maybe you're familiar with it in different levels. This is a promise made by one party to the other to act as an insurer. If I do something in the delivery of my goods or services or my scope of work that injures you as my client, I agree to be responsible for your costs related to that. Now, that's kind of fine in concept, but one of the things that clients often see requests, particularly bigger ones, is a very broad indemnification with unlimited liability or way beyond the scope of your service. And one way to think about that is if you're doing a $10,000 job, you can't take on $1 million of indemnification obligation. Because at one point it's going to come back to haunt you. So you need to kind of calibrate your indemnification to the things that you're in a position to control, like, is the service that I'm going to deliver safe? Are my people going to do what they say they're going to do? But not things that might be outside of the control, like if somebody slips and falls on the property, who's responsible for that? Or if you deliver a machine and they modify the machine in some way, once they modify that machine, that's no longer your responsibility if the machine fails to do what it's supposed to do or injure someone. So again, we're here to help you think about those when you see specific language, but an indemnification and this related term that we're going to talk about are important ways for you to balance the risk appropriately for the job that you're going to do. I know you're going to stand behind your work or your product, but not move beyond that to act as your customer's insurer. And by the same token, if you're bringing a subcontractor in or somebody to do something, you want to make sure that you're pushing down to them an indemnification obligation that is consistent with what they're responsible to do and what they're in a best position to prevent. So one way that we limit an indemnification is by a limitation of liability clause. And again, you get to this by thinking about, well, what are the risks that I'm in the best position to control, A, but B, what's the size of the job? So a lot of times you'll limit liability to some multiple of fees, for example. So you would say, if I'm putting a porch on your house, I'm not taking on $1 million of liability on a $25,000 porch, but I'll take on 50 in case I do a horrible job and the porch falls down and Granny tumbles down the stairs or whatever. So you can think about your risk in the context of your reward, in effect, or the compensation you anticipate. And again, we can look at those with you. The other piece I see, I guess maybe it's in the next slide here. Oh, let me just do this. Let me just do these out of order, and then I'll go to the last one, is that you can have in your contract, and you should have in your insurance, which is critical, your insurance should be able to cover claims made against you for work that you did that maybe didn't turn out, negligent work particularly, that didn't turn out the way that you wanted, where you meant to do it right and you made a mistake, not where you acted intentionally to harm someone. But again, the three legs are your contract, and well, the two legs are your contract and those terms and these insurance provisions that would be in the contract that will respond if one of your customers comes to you and says, hey, that machine you sold me blew up and injured someone, or the stairs you built me fell and somebody got hurt, or somebody infringed on my intellectual property, and now I've got a lawsuit and I need you to respond to that. So insurance is a great way. Insurance is typically cheaper than we think. It's a good deductible business expense. So you want to make sure you've got a good policy from a good underwriter and a good insurer that's going to cover appropriately and efficiently the risks of your business. So another one here, just to kind of go through these in order, we talked about product liability and personal injury damages. Because of COVID, people are buying business interruption policies now, which actually not a lot of people had before COVID, and now the rates have gone up. But this is a policy that would respond and basically pay your anticipated revenues if your business is interrupted for any of the reasons that are covered in the policy. Again, typically you want to be a little bigger before these start to make financial sense for you. But on the flip side, we have people who think about these things from an accounting perspective and so on, and they would tell you that there are ways to be thinking about putting aside reserves if you can to anticipate these kinds of losses. So again, come back to us and let us look at your business and see if we can help you think about that. A key person policy or key man policy means if you're the solopreneur or you're the person that really drives the business and something happens to you, you get disabled, you're unable to work, you're unable to play a role in the company, you can insure that risk. And they'll step in and they'll compensate you. They may compensate the business's loss for your inability to go out and generate business or deliver the services or whatever. So again, it's a conversation you can have with your insurer about that. And one company that I'll point out, there are millions of them, but there's a company called Hiscox, HISCOX.com, that seems to do a pretty good job. I've seen a lot of their policies for small business owners. So, you can reach out to them. You can always get a quote. It's always good to freshen your insurance coverage every year or two. Your business may have grown. The nature of what you're doing may have changed. So, again, it takes you away from doing what you want to do, which is run your business and sell your products or services. But it's often time well spent to have that done. And a lot of times, as you get a little bigger, a relationship with an agent or a broker, again, is money well spent. And the last one is just an umbrella policy is a way to roll all your risks into, kind of aggregate them under a claim, under a policy. Sometimes you can get better rates, or you can get a tiered system where you have insurance of certain types up to certain levels, but then you say, if just in case something punches through that and I have one really catastrophic event occur, I can put a little umbrella on top of that. So you might have $1 million of general insurance and have this catastrophic umbrella on top of 5 million or 2 million if something happens. So, but again, it's something you want to talk to your insurance broker about, or whoever's writing your insurance for you. And just finally, a few minutes here on intellectual property. If you're in the business of selling ideas, selling services, even if you don't have, I'll put aside trademark for a minute, but if you've got a proprietary way of doing something, if you've got something like that, then you want to think about protecting those rights as trade secrets. Obviously, if your business is based on something that is patented or patentable, you want to think about how you're going to protecting that. Even if you just have a website, you want to think about protecting that through a copyright. So trademark protects your trade name. And the basic rule there is you own the trademark when you use it. As long as somebody else doesn't own it, you can look at that trademark, you can put the little TM on there immediately. And the only thing you can't do is register the trademark, which requires you to go to the United States Patent and Trademark Office. But I tell a lot of small businesses, it's not worth the time and expense, because all you really get from a trademark registration is the right to sue somebody if they infringe. But for most small businesses, you may not have the resources to sue if they're infringing anyway. So we really want to think about what value you're actually getting there. But things like trade secrets, you can be protecting by non-disclosure agreements, by contractual terms, and so on. Patents is an area, again, that requires more to say than we may have time to do here. But what I would say is the patent process is lengthy. It's going to cost between $15,000 and $20,000. So if you aren't certain that you have a viable market for your product first, don't start a patent. It's the best advice I can give you, because I talked to a woman the other day. She had no idea what the market was for her invention, but she had already spent $12,000 on a patent. And I said, well, who's going to buy this? She said, well, it's a $5 billion industry. And I said, well, what piece of it do you think you're going to get? You know, you're competing against, it was a beauty product. And I said, you're competing against the major beauty product companies. And she hadn't thought that through, and she had spent $12,000, which was very sad. So copyrights protects written expression, movies, art, and so on. You own a copyright like a trademark when you protect it, when you create the work. You can put the C on there right away. There are some benefits to copywriting works, particularly if you do a lot of things. But if you're just copywriting your content on a website or so on, just put the copyright on there and maybe get your focus on other elements of your business. Again, we're happy to talk to you about those things as we go by. I'm coming up to the end here. I'm going to skip state, federal, and foreign protections and just say this about, if you're in a position where you have intellectual property to sell, or you're in a position of looking to buy that, there is a continuum of compensation strategies out there, from outright purchase to royalty agreements and so on. So let me just say that if you have those questions, you can contact me. We have an excellent patent, copyright, and trademark attorney. I've commercialized a lot of intellectual property. So let us know what your specific needs are, and we can help you think in a little more detail about how to turn that potential deal into a compensation structure. So I will stop there. I hope you found this useful. If there are any last questions, this would be a time to ask them. I'm going to stop sharing and we'll go from there.
I think we might have a question trying to come through. We want to
Okay.
just wait a few seconds,
Sure.
because I see Bill, comma in the chat. So I'm guessing there might be more to it than that.
Yeah.
But in the meantime, I just want to thank you, Bill, for
Sure.
giving us an hour to go through all those details, because I know that those are very complex things to have to work through as a business owner. So thank you for that.
You're welcome. Let's see. Let's see here.
For copyrights and trademarks, all you need is to use the T or the T or C symbols. Question?
Yeah, so go to copyright.gov. It's in the Library of Congress, but it's uspto.gov for the trademark, and there's an FAQ that'll tell you exactly how to do it for a service mark or a trademark. And you can go to copyright.gov and you'll find the same information, because it changes a little if you're copywriting a written work or a song or a video or something like that.
And somebody asked about your contact information. If you want to schedule with Bill, please go ahead and email me at outreach@scoreboston.org. And I have access to his schedule and I can get you on his calendar.
Excellent. Yeah. Hope you find that useful.
Reaching out to you for assistance with commercializing a product I'm currently working on.
Okay.
Okay, great.
Yeah. Reach
All right.
out to Teresa, and that way we'll get together and we'll do that.
And again, that's outreach@scoreboston.org. And I will connect you with Bill's schedule. Okay, great. I'll give everyone thank you for joining us, and enjoy the rest of your day. I'm sure it's beautiful outside. So thanks.
Thanks again. See you, Teresa.
All right, bye.